call to order. My name is Claire Finklestein. I'm a faculty member here at Penn Law, and I'm delighted to have the opportunity to moderate this last panel of your very impressive Federalist Society seminar. I should say briefly that I am also the director and founder of a center called Center for Ethics and the Rule of Law that deals with ethical issues connected with national security. I've been delighted to partner with the Federalist Society on a number of occasions, as many of the issues that we deal with in my center overlap with Federalist Society concerns, and this panel is certainly one of them. So I salute you for your work and for this symposium and for the topic of this panel, which is extremely important and interesting one. Our two speakers today are Charles Stimson, who is the manager of the National Security Law Program and senior legal fellow for the Davis Institute for International Studies at the Heritage Foundation. He is a widely recognized expert in national security, homeland security, and crime control. And Professor David Rudovksy, who is a member of the Penn faculty and one of the nation's leading civil rights and criminal defense attorneys. He practices public interest law with the firm of Carys, Rudovksy, Messing, and Feinberg. He became a senior fellow at Penn Law in 1988, and he teaches criminal law, constitutional criminal procedure, and evidence. They're both widely published authors and very well known in their fields. So looking forward to their remarks. They'll speak each for about 15 minutes, and then I'll throw out some questions for both of them to contrast and compare their positions, and then we'll open it up to audience questions. So we'll start with Professor Rudovksy.
Thanks, and good to be here, and thanks for the invitation. So just to set the context, when we both looked at this topic that you asked us to talk about, surveillance and privacy, we were glad how you narrowed it down for us so that we really wouldn't have any choice what to talk about. So we did talk, and obviously there's a lot there in terms of that topic. And what we thought would be appropriate and probably most useful is to focus on one or two main areas. We'll touch on others. But as you probably won't be surprised, what we thought we would debate, discuss, and how much it's a debate and how much we discuss, we'll find out from the remarks, is on Section 215 of the Patriot Act, which of course is the Snowden disclosures, the telephone metadata, and the government's collection, as we now know, for the past 10 years or so, of every phone call that has been made in the United States by everybody in this room and across the country. The implications of that, the legality of that, some of the constitutional issues, and again, this balance between surveillance and privacy, particularly in the context as it is, and the reason we have this issue before us is the post 9/11 war on terror. So we're both going to address that. We'll address some other issues as well that we think relate to that main topic. We want to use this as a kind of example of a current and perhaps the most significant conflict, at least in the public mind, between government powers of surveillance and individual privacy. I want to put it in two contexts before I get to my discussion of Section 215 and my own views on that. And the first is its relationship to other important issues and debates we've had over the past 15 years on the war on terror, because surveillance obviously is just one tool that the government uses in the war on terror. We've had significant debate and disagreement about other tools that the government has used, the initial detentions after 9/11, the question of whether you call it enhanced interrogation or torture of suspects, questions about military commissions, all the issues around Guantanamo, more recently questions about targeted killing by drones. All of those, while they're not necessarily surveillance tactics, obviously relate to a larger picture of how the government goes about conducting the war on terror. And I think they are related in ways that I'll mention and raise probably the most fundamental questions about our constitutional values and what I'd call our small d, democratic values as well. Because all of those operations, whether you look at them together or as individual parts on the war on terror, raise very important questions about transparency versus secret governmental operations, unilateral exercise of executive power, the whole major issue that you've been discussing all day today, limits on judicial review, and so on. And as again, I'll say, we'll use Section 215 to illustrate that. Second context I want to put this in is a more historical context, and that's really the question that's posed anytime we or any other nation goes to war, whether it's a real war or a metaphorical war, because no nation does well in terms of protecting civil liberties and civil rights when we're at war. We haven't done it. No nation does it. Best you can probably hope for is that whatever mistakes you make during the war, you correct afterwards, and you get back to where you should have been before. But if you just think quickly about our history, Civil War, Lincoln suspended the writ of habeas corpus, basic right in the Constitution. World War I brought significant repression on First Amendment rights. Eugene Debs, a candidate for president, was sentenced to 10 years in prison for what? Criticizing the draft. That's all he did, criticize the draft. We sent him to prison for 10 years. We had the Palmer raids after World War I. World War II brought maybe the most significant stain on our constitutional history, incarceration of Japanese citizens in the United States. On what grounds? Because they were Japanese. Nothing. No real fear. There was a lot of fear. No real facts to suggest that any of them would be a threat to us during that war. Post-World War II, we had the Cold War. We had McCarthy. We had J. Edgar Hoover. We had all kinds of issues about civil liberties during that time. And even on the metaphorical war, like the war on drugs, when we declare war, we've got to be thinking about the consequences for civil rights and civil liberties. So we know from history that that's what happens, and unsurprisingly, post 9/11 and the war on terror, the same kind of debates have arisen as to means and ends in terms of what the government is doing. Of course, we could take some solace from history in the sense that at least the past wars had a beginning and end, right? The Civil War, World War I, World War II, kind of even the Cold War, right? And so we could probably get back to more normality after those wars. Not so clear to me that the war on terror will ever end. That's probably something, certainly in our lifetimes and our children's lifetimes, we'll be fighting for a long time. So it's not a war that's easily marked. And maybe even more important, as 215 will illustrate, we are now, because of new technology, building in methods of surveillance and control that will survive the war, that will be used or not used in good or bad ways, regardless of whether we're at war. So we have kind of different kinds of issues to deal with. And the third point I'll make, just again, kind of just by perspective, is because obviously we're having this conference and this debate today in part because Mr. Snowden released his data. Probably we wouldn't be here debating this because nobody knew. Well, not nobody, a few people knew what the government was doing at the time. But if Snowden had not released his data, we would have not had this national debate about what kind of surveillance we ought to be conducting, how broad, what kind of information we ought to be collecting, how it gets analyzed, how it gets distributed, so on and so forth. And obviously everybody has their own views on whether he did the right thing or the wrong thing, whether he's a patriot or a criminal. I think that's not so important, but it reminds me, and it's almost bookends for me in terms of my legal career, it brings me back to 1970 when there was a similar event. Anti-war activists in Philadelphia did a burglary of the media FBI office in Philadelphia, suspecting that the FBI at that time, although they had no proof of it, was engaged in widespread surveillance of political dissidents in the 1960s and early 1970s. Turns out they were absolutely right. They stole thousands of documents. Those documents showed that the government was involved in fairly high-level illegal activity. Operation called COINTELPRO, which was intended to disrupt and destroy people that J. Edgar Hoover thought were to the left of the center, or the left of the right, I might say. And again, it was that kind of disclosure that led to, as the Snowden disclosures, public debate, the Church Committee investigations in the 1970s, the reforms in the CIA and FBI. But when you think about that point, what they found in those files, those 1,000 pages or something, were kind of discrete operations, Martin Luther King, other political activists, to try to disrupt them. The disclosures from Snowden show a far different type of operation, in some ways not targeted against a particular individual. The problem with the Hoover era, of course, was that it was targeted against political enemies. What we have now, particularly with 215, is kind of a vacuum-like collection of data without even knowing how it may fit into the puzzle later, not necessarily against a particular person. There are some similarities, but as I say, in the War on Terror and 215, there are going to be different questions that we're going to have to answer. So let me talk about 215, and again, talk about the issues that raises, and again, put it in this larger context. The Patriot Act, which was passed in 2001 after 9/11, had a lot of controversial provisions. One of them, which became the now Section 215, permitted the government to require tangible items, documents, simply by requesting them almost by subpoena. And as I think the early debate was whether they could use that at libraries and so on. It's kind of a quaint debate when I think about how much information they have now, but even controversial in the beginning. That act was amended in 2006 and was amended to read as follows. And I'm not going to be doing a lot of statutory construction here, but let me tell you what that statute is, because it's important to understand what powers the government claims. Under 215, the FISC, the National Security Court, may order disclosure to the government of, quote, tangible things relevant to an authorized investigation, not just a threat assessment, but an authorized investigation to obtain foreign intelligence information not concerning a U.S. person, or to protect against international terrorism or clandestine intelligence activities. In other words, if there's an investigation going on concerning terrorism, the government is entitled to secure tangible items, very broad, right? Almost any document or any piece of information, if that information is relevant to the particular investigation that's going on. Within a short time of that statute being passed, the government got a secret order from the FISA court, allowing, as we now know, although we didn't know it then, almost 10 years ago, allowing the government to compel communications companies, phone companies, to divulge the fact of every phone call that was made in the United States. Had nothing to do with foreign intelligence. This wasn't information about people in Europe or the Middle East. These were U.S. citizens. Every phone call, information, data about that phone call was now swept up and obtained and stored by them. Okay. That became the practice. Again, we didn't know about it because of lack of transparency and secrecy until Snowden revealed that fact in 2013. I just have 3 or 4 minutes, so let me make 2 central points about what I think about that program. Number one, under the Act, it is what I would call a stunningly overbroad overreach to think that the government could say, because we are involved in some overall terrorism investigation and war on terror worldwide, that we can, under this statute, say that every phone call that's made in America might be relevant to that investigation. If that's true, every transaction you make, whether it's a purchase at a restaurant, by a credit card, by a book you read, every transaction, everything we do could be, right, could be somewhat relevant down the road to a terrorism operation or investigation. I mean, that's how broad the government's theory is, that all these calls, without knowing what they are and what they might be, become relevant to that kind of operation. So just on the face of it, fairly stunning construction. Indeed, the Privacy and Civil Liberties Review Board that was set up after the Snowden investigations said the following: if the government has effective means of searching everything to find something, everything is now relevant to all investigations. And that includes data, emails, credit cards, financial records, everything. And so that's the position. So that's the point. I think, obviously, this is an overreach, and they were able to overreach it because there was no transparency. It was all secret, right? If the public had known 10 years ago about this, we'd have the same debate we're having now. Second, even if Congress intended that, even if that was Congress's intent to allow the government to seize it all, as you can imagine, we've got serious Fourth Amendment problems with that kind of power. That issue is now being litigated, as you may know. District courts in New York and D.C. have split on the issue of whether the metadata program is constitutional. The New York case is now before the Second Circuit. We'll have decisions soon on that. But just let me lay out in 2 minutes my theory as to why it's unconstitutional. The government makes pretty much a single argument. What the government says, using an old case called Smith versus Maryland, which involves this third-party doctrine, well, when you make a phone call, you disclose the numbers right to the phone company, right? So that's out there. You no longer have any expectation of privacy. And of course, Smith was a single case of a few calls that were made and a pen register, and there it is. So that's the government's theory. We can collect all this information because while it may be normally private, once you dial numbers or put numbers out there, you expose them to a phone company, therefore you've exposed them to the world. Nothing wrong for the government to seize all of that. I think that doesn't work when we talk about metadata. It doesn't talk about when we talk about the type of surveillance that we're talking about here. And what will be interesting, of course, on that point, and we can explore it more, is two recent cases in the Supreme Court which I think call into serious question that doctrine, both of which you probably know about. One is the Jones case, which is the GPS case in D.C., where the court unanimously said using a GPS device to surveil somebody for 4 weeks, 24/7, right, was different than the kind of individual following of somebody for 2 hours. If you have a police officer following somebody in public, that's fine. GPS device, which discloses the same kind of information, all public movement, not fair, right? Not fair. 9 justices, for different reasons, said that was unconstitutional under the Fourth Amendment. And then just last year, in a case that may have some relevancy on this as well, Riley versus California, the court made a similar move, case in which there was an arrest of a person. Incident to the arrest, the police seized his cell phone and then obtained information from the cell phone, which, again, the government had a pretty good argument. Search instant to the arrest, you don't have to show any probable cause. You can look at whatever you seize. Supreme Court, again, 9-0 said the world is different. Cell phones contain very much personal information. They may contain information that shows a lot about our lives, our political associations, our medical problems, our religious associations. When you think about what you have on your cell phone, your whole life is there. Other people's lives are there. And therefore, the old doctrine about search instant to the arrest has to be modified. And so when you stack those two cases up against the theory, which certainly worked for individual phone calls for one person, when you talk about the kind of data that it sees now, and without even getting into content, that data can show enormous aspects of everybody's lives. It'll show our religious affiliations, it'll show our political associations, yours and mine, whatever they might be, if that data's there. Now, I know what we're going to hear is that program only allows the government to collect it, not necessarily to analyze it, but we'll discuss that further when we go along.
Thank you. Mr. Stimson.
Claire and David, thank you, and thank you to the Federalist Society for inviting me here. I assume you think that I'm going to sit here as an employee of the an employee of the Heritage Foundation and speaking on the Federalist Society's behalf, and I'm going to vehemently defend 215. I'm going to start in a different place, and it's where I think the people who framed this symposium started, and that is this notion, I think, that has been played out very well today in the various discussions, that there is an ever-encroaching federal Leviathan, an ever-encroaching encroachment, penetration of our privacy as citizens. David and I and Claire were talking right before the panel, and we said it's an odd world we're living in right now where the generation of students who typically are in law school are posting all sorts of things on Facebook and Pinterest and all these other things to social media. I mean, your notion of privacy is different than David's and mine and Claire's notion of privacy. And I would say anyone over 40, really, frankly. I mean, you wouldn't have even thought, well, we didn't have the technical means. You wouldn't even have thought of posting pictures of yourself in a bathing suit for the world to see when you're on summer vacation, but now we do it in a prideful way. My comments are shaped in part because of my 23 years in the Navy as a JAG, in part as the person who was in charge of detainee policy in the Bush administration as Deputy Assistant Defense Secretary, and in part as a federal prosecutor. I agree with a lot of what David said, so I'm not going to focus on the redundancies. I'm going to focus on framing this a little bit differently. I think it's easy to conclude, frankly. You wouldn't need a symposium. You'd need about 30 seconds or Hadley Arxis to give you 5 minutes of his brilliant oration, that the federal government has grown too big, too intrusive, and too powerful in the area of national security. It's very easy to assume that. And those fears are quite frankly amplified, and rightly so, by news that this Justice Department has been spying on reporters to the Associated Press, on the New York Times reporter James Risen, and on Fox News reporter James Rosen. Just today, a Pew Research Center poll was released. 671 journalists were polled, and 64% felt that they were under some form of U.S. government surveillance. I mean, that is a shocking thing to think about, that our free press feels, for whatever reason, that they are being watched by our government. Our views on surveillance and national security are also influenced by the fact that we know that the IRS intentionally targeted groups, some associated with the Tea Party and other conservative groups, and slow-walked their 501c3 applications to thwart their effectiveness before a national election. And our discussion of the expansion of federal power in the context of national security is influenced in part because of the distrust of this administration and previous administrations outside the context of national security. David touched on some of them. I'm going to touch on a few others. Unilaterally deciding to delay an employer mandate of a major piece of legislation, here the ACA. Waiving the TANF work requirements, allowing states to waive Section 407 work participation rules. Making 4 recess appointments to the NLRB when the Senate was not in recess. Abdicating the duty to defend a law before the courts, which you said you believed was constitutional, and then you flip-flop and don't defend DOMA. There is a lot of litigation going on that I think influences our debate today regarding 215 and surveillance. For example, David touched on military detention and Gitmo and military commissions. Obviously, those are topics in the news. The commission's cases are ongoing. The no-fly list litigation, Latif against Obama, is ongoing. The Microsoft litigation, which some of you may know about, which tests the geographic reach of the government's warrant requirement under ECPA. And the cell site geolocation data case, United States against Graham, and then, of course, the TSA litigation. We've already given up, like it or not, some of our privacy, and we know this because all of us fly places. The TSA, the wily TSA, searches us, and those searches have changed over the years. Now, no pocket knives, liquids under a certain number of ounces, but we have ceded to the government that privacy in the interest of being safe. My point is this: the cumulative effect of those actions and scores others, going back to the Bush administration, think the terrorist surveillance program, set the stage and all preceded, or most of them preceded, the disclosures by Edward Snowden. And in my opinion, the administration was caught flat-footed, as any would have been, by those disclosures. And frankly, they did not adequately explain the policy or legal rationale in real time for the need for FISA, and in particular Section 215. And by not explaining the programs to the public to the extent practicable at the time, and defending their legality, they lost the public relations debate, frankly. And the high ground, the moral high ground, to those on the left and right who were naturally suspicious of an overarching, overreaching, overbearing government. Now, I will tell you, I'm not going to hide the ball. I think that these programs, in particular Section 215 and 702, have been effective and they're constitutional. And we can debate that during the question and answer. And I also think, along with a lot of other people who are currently in the government and who have left the government who've intimately worked with these programs, that the Snowden disclosures have been exceptionally damaging to our country. They've damaged our relationships with foreign intelligence partners. They've damaged our ability to be trusted by other countries in the fight against ISIS and al-Qaeda and their affiliates. But I think the debate since Snowden has been healthy for our country. And I think it's healthy because we are a strong country and we can debate these things in a thoughtful way. That by no means excuses what Snowden did. And Claire, I'll beat you to the punch. I think he's a traitor and I think he should be convicted of violating federal law. That was he was supposed to uphold. He's not a hero in my mind. Our country was born into war with the Declaration of Independence. And the founding generation knew firsthand the oppression of tyranny. And to that end, the task, observed James Madison, quote, in framing a government which is to be administered by men over men lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself, unquote. And David pointed out, I think quite rightly, that we have not been able to control ourselves sometimes, but the pendulum swings back, and that's what's happening right now. Any power delegated by the people to their government may be abused and used against them. Let me jump to, because I thought Hadley's lunchtime speech was perfect, because I have a section here that I'm not going to include, but I'll tell you the headline, and that is, I was going to spend a little time talking about how the separation of powers, not only horizontally but vertically, is a bulwark against programs such as 215 and others that we find repulsive, or that a federal court perhaps will find extends the relevancy standard beyond anything we would ever dream of. David talked about the Fourth Amendment, and we're not going to get into a long discussion about the Fourth Amendment, but let me tell you why I think 215 is constitutional and complies and is compatible with the Fourth Amendment. Whether we should have it as a policy going forward, that will be debated, because you know Section 215 expires at the end of May, and Congress is going to have to do something, or it will expire. But first off, Section 215 does not collect the content. And when I was a federal content of the calls, and so when I was a federal prosecutor, or state court prosecutor for that matter, I could, and often did, write a letter to a telephone company and ask for the telephone calls associated with this number and this person, and they would turn it over. The court was hardly ever involved in that process. I didn't get the content of the calls. I got the numbers they called, when they called, the date they called, and the length of the call. Why should we not have our national security professionals have access to the same thing that prosecutors in this state and every state and the federal government have every day? We should. Last September, Matt Olson, the head of the National Counterterrorism Center, gave a speech at Brookings, which I think you should read or watch if you haven't. He said that, quote, ISIS poses a direct and significant threat to us and to the Iraqi and Syrian civilians in the region, and potentially to us here at home. But this week, FBI Director Comey said that ISIS is trying to attack us now in this country. That's a significant step up. I'm not saying that justifies losing our liberties or sacrificing it. What I'm saying is, when the DIA director who testified today says this, quote, today's security challenges are more diverse and complex than those we have experienced in our lifetime, unquote, you have to say, what are the means to get to the end state. And the end state is the security of our liberties and the security of our people. Using a tool that is common in criminal practice, that does not involve content, does not trigger the Fourth Amendment. Last year, there were 114 queries through the NSA of seed numbers known to or thought to be associated with terrorists or terrorist organizations. That's it. So we can talk about trillions of calls and billions of calls and all the rest of it. 114. Were you impacted by that program negatively, and can you prove it? If so, raise your hand right now. Let the record reflect not a hand went up. Let me end with this. This program has been authorized by Congress, amended several times, including the 2008 amendments, overseen by the FISA court, and overseen by an extraordinary bureaucracy, over-lawyered to some people's mind, within the executive branch. And since those disclosures, you have seen the establishment of the PCLOB. How's that for a DC name? Privacy and Civil Liberties Oversight Board. You've seen another board within the executive branch overseeing this. You see the Director of National Intelligence, a critter created after 9/11 that is apart and separate from the CIA but works closely with the CIA, set up a website called I See on the Record. And you can go to their website right now and read everything, and trust me, the enemy is, that they're doing to amend and change and modify and bring the program even further into transparent compliance with above and beyond what the Fourth Amendment would ever require. And I'll end with this. The PCLOB issued on January 29th their recommendation assessment report. And these are not mandatory. These are recommendations that the executive branch can take. And it's laid out in various sections: targeting, U.S. person queries, foreign intelligence surveillance court, upstream and about collection, transparency, et cetera. A bunch of different sections. And you can see that over half of their recommendations are already being implemented, including, but not limited to, U.S. person inquiries. Update the FBI's minimization procedures to accurately reflect the Bureau's querying of Section 702 data for non-foreign intelligence matters, and place additional limits on the FBI's use of 702 data in such matters. And it goes into 702 and 215 and all the reforms. So the administration could stop using 215 today. They're not. They choose not to. Whether the Congress extends 215 in May, I don't know. There's a bill that died on the Hill last year, the USA Freedom Act, that suggests it should go away. But if you ratchet down the procedural requirements to use a tool like that to the point where it's unusable, you are then exposing yourself and allowing the enemy to exploit that loophole. The same thing that existed right before 9/11. Thank you.
Can you bring the chair over better? Okay, I'm now going to ask a few questions, especially because it's so interesting to compare the positions of these two experts, to try to draw them out on a series of issues, and then we'll open it up to audience participation. So the first question that I have concerns the relationship between the Fourth Amendment and ordinary surveillance, especially 215 metadata collection. The line of cases that both of our speakers referred to is mostly developed under the Fourth Amendment protection against searches and seizures. And this, of course, applies to criminal suspects only. What does the ordinary citizen who is not a criminal suspect have by way of protections against unreasonable searches and seizures? And is there some irony in the fact that greater protections have been extended to criminal suspects with regard to bulk data collection than have been extended to Americans who are not criminal suspects? David, I'll ask you to start on that question.
No, a good question. And what's really interesting, of course, is the government's position over these years. Not only have they kept this program secret, but then when parts of it came out and there were lawsuits filed, the government argued, well, prove, right, that you were harmed. And by the way, Supreme Court, they said to the Supreme Court, you really don't have to worry about Amnesty International's lawsuit or ACLU's lawsuit where they say that given the scope of this program, of course we were overheard. These are people we talked to. These are our own phone calls. Overheard in the sense that the data was collected, not that the content was actually accessed. And the Solicitor General told the Supreme Court, don't worry about that. In criminal cases, this can be litigated because we have to inform a criminal defendant if any of the evidence resulted from this kind of data review. Turns out nobody was being informed. The government was not informing criminal defendants. They weren't informing anybody. So there is an irony, right? Both that only the criminal defendant would have some kind of theoretical chance to raise this issue in court, and that the government not only keeps this secret for 10 years, but then when enough information comes out to know that people's numbers have been called, that this data has been collected, that with respect to overseas communications probably have been overheard, the content has actually been accessed, including U.S. citizens, the government's first response, you don't have standing. No court can decide this issue, which is another version of secrecy. Don't let anybody decide but the executive. So I think that point. The second point I make on that is just related just in part to what Cully said, this question of whether it's constitutional. What's ironical to me is when you think about the revolution in this country, and the reason we had the Fourth Amendment, there was a practice by the British called the writs of assistance. These were these general warrants that the British used because, truthfully, there was a huge amount of tax evasion in the United States. The British had imposed tariffs, right, and taxes on non-British goods. Those laws were violated every day by not by every colonist, by many colonists. And so Britain started this policy of these general warrants which gave their officials the right to search any place at any time to find these goods. Somebody said the argument in that case was the first blow of the revolution, right? There was such animosity to that. Well, compare that, which at least had a factual basis, right? They were right. There were colonists all over the United States who were violating those tax laws. Now you've got the same kind of writ of assistance, right? We will sweep up all the information we can, not even because we think any of it is going to be relevant, because it might be relevant sometime in the future. So for those of you who like James Madison, right, and think that we really had a reason for the Fourth Amendment, if you can distinguish between those two programs, I'd like to hear it.
I have a lot of sympathy towards David's first point, frankly, having spent a lot of my time as a defense attorney. Imagine if you were representing somebody who gets convicted in state or federal court through what you thought was a fair trial, only to find out years later that the seed of one piece of key evidence was actually provided to the government backdoor through the intelligence community through a 215 or a 702 connection, and then it was, washed and made vanilla into standard evidence and then put in through the normal course of the evidentiary process and resulted in your client's conviction. That's happening now. Some of those cases are actually being litigated, and I have a lot of sympathy towards those cases, whether the government can make its case beyond a reasonable doubt against the defendant if they choose to retry him. I don't know. I think prosecutors are certainly entitled to and must strike with firm blows, but they need to be fair. And part of the fairness is they need to disclose and push back hard against the very government they're working for to be able to tell the defense and the judge, at least in camera, where the information came from. To the second point, though, the data that is being swept up under 215 is not yours. And so, yes, 702, which is focused on international or non-U.S. persons overseas, is the much bigger tamale. It's the huge program, right? And what some have said is, look, if you have to give up 215 to preserve 702, it's worth it because really we're worried about the overseas. Here's the problem. We know, and the Bush administration had this problem to some extent, the Obama administration really has seen more of this, that ISIS, which grew out of Al-Qaeda, is recruiting Westerners. Westerners are flocking to train with ISIS. And so you see in the news just in the last month, people who were inspired by ISIS, Westerners here in the United States, either self-radicalize or reach out, think the Fort Hood situation to the enemy. And so, yes, the Fourth Amendment is implicated. Yes, the Fourth Amendment, people are treated differently with respect to 215, whether they're a citizen or not. That is the difference. And that's what we should demand as a citizenry, that you have Fourth Amendment protections and considerations in play for citizens, whether they're located in the United States or outside the United States. And that's where I think this debate has been very healthy, because it tells you as a citizen that you take the Constitution and wrap it around you wherever you go.
Charles, are you suggesting that Fourth Amendment guarantees should be extended to non-criminal suspects to protect the privacy rights of Americans in certain areas, for example, in the 702 area?
What I'm saying is I think that the administration has struck the correct balance right now, in that if during an inquiry, let's say in the 702 context, which is content-based, they come across information from a known non-U.S. citizen who's in contact with a U.S. citizen, they apply a different standard internal to the executive branch to that person. They may not look at the content. They may have to develop additional evidence to get to the point where they have probable cause to launch a criminal investigation through the FBI. But one thing I cannot do is tell you, because I'm a naval officer, and the Secretary of Defense ordered all active duty and reserve officers not to read the Snowden disclosures. I can't read the very things you all can read because it's still classified. So I can't tell you what's in the prison program, and if I knew, I still couldn't tell you.
So under the 702 data collection program, you can collect content-based data on Americans, but it has to be incidental to the collection of data on a foreign national who poses a national security threat. And then the data that you incidentally collect on Americans can be stored for, I think, up to 5 years. Is this a legitimate program, and is it reasonable to distinguish between cases in which the FBI or the CIA might target Americans for information collection versus cases in which they incidentally are able to collect data, content-based data, because they're targeting a foreign national?
Yeah, so the 702 is an important distinction. That's the foreign intelligence gathering, much broader in terms of what the government is able to look at, its content, versus just the fact that calls were made or emails were sent. And it's a lot of content. It's emails, it's phones, it could be a lot of information that's out there. And obviously, once you start surveilling foreign persons, inevitably in this world, you're going to have them contacting, rightfully, legally or not, American citizens, journalists, lawyers, businessmen. There could be thousands, millions of very legitimate, right, conversations and communications between American citizens and foreigners and people in foreign governments that could be subject to the 702 sweep. And that's a huge sweep as well in terms of what's gone. And I think the key point there is, and it has to be incidental, that at least from the U.S. citizen's point of view, that those contents should not be available and read unless there's a heightened cause, right? That we have some good reason to think, as a result of other information, that those contents would actually reveal assistance to terrorists or illegal activity on the terrorism front, and it might require require a separate warrant. But I think there we've got to be pretty careful about how we do it.
Can I throw something in here, Claire? These debates are important as part of civil society. But when you're charged with actually defending the country, and you know that the enemy is literally translating your government documents, which are disclosed illegally, or published through the normal course, almost in real time, and see that the enemy is adapting quickly and changing their modes of communication as a result of these disclosures, you have to decide, academic debate aside, are you going to do something about it within the context of the law, or are you going to give up a capacity, even if you have to amend it to the point where it's not as effective as it was at all? And so I think that we need to keep in the back of our mind that the enemy is life. The enemy is adaptive. The enemy...
Charles, I'm glad you raised that, because let me just ask you, why then limit 702 data collection to, other than that it's statutorily authorized that way, but so long as we're thinking about statutory reform, why limit it to incidental data collection on Americans? Wouldn't we be more effective if we allowed the NSA and the FBI to engage in direct targeting of Americans for data collection? Why require a foreign national?
Because, frankly, it's a matter of reality. There's not a lot of Americans engaged with ISIS and al-Qaeda. And we have to have some protection from our own government. And in inserting these, what I would call speed bumps along the way, which are constitutionally Fourth Amendment-based protections, guard against government employees who are acting rogue,
I'm sorry, let me
et
just
cetera.
stop you there. But the Fourth Amendment doesn't apply here, right?
Right.
Because they're not criminal suspects. So what do you do about that? We don't have any more a notion of substantive due process. That might fill the gap here, protect a kind of general notion of liberty. Is it time to revive substantive due process?
Well, that's a whole different panel, probably a whole symposium.
But is that what we're doing when we're sort of extending the Fourth Amendment beyond the arena of criminal law?
Well, I think it's a pragmatic application here because, having sat in the room where some of these decisions have been taken outside the 702 or 215 context, but in detention, interrogation, military commissions, I can tell you that people really think long and hard, and these are liberal friends of mine and conservative friends of mine agree vehemently on this. You don't want to give the federal government the green light to do everything it's capable of doing. You just don't.
So let me give you a hypothetical. Just a couple more questions before we let the audience in. Suppose local law enforcement officials are struggling with an unsolved murder, and these cases continue. They think they're dealing with a crime spree from a single individual. Now, the NSA has said that it does not share metadata or 702 data with local law enforcement agencies. And they've said that by way of trying to reassure the American public that they're respecting constitutional boundaries, not doing an end run around the Fourth Amendment as you suggested. So it was designed to reassure. Is the NSA doing the right thing, if indeed it is withholding information from local law enforcement, or should it go ahead and share that information, David?
I'm trying to see the nexus here. I mean, there's a large question here about, obviously, information we gather for intelligence purposes.
And the NSA thinks, you know what, we've got some information on that might help them solve this.
But I'm not sure what NSA would have. If NSA has, because some of its agents have information about that murder investigation, I don't see any problem with NSA advising local police. If the question
and it would
but if
be
the question
illegally
is,
collected then under the Fourth Amendment.
If it's illegally collected,
But not under an NSA program. For
I
local law enforcement, it'd be
I think
illegally
that can't be
collected.
used. But assume that some of this is collected properly, and some of it might, and it's just I'm not sure the data actually that NSA has. I'm having a hard time seeing how that's going to be helpful in this murder investigation. I mean, are there phone records, right, about a suspect? But that's the target investigation. In fact, when Cully said, look, when he was a prosecutor, he could call, right? He could call a phone company and say, what do you have on John Doe, right? But there, we're already in an investigation. We have some reason to believe John Doe is involved. There's been an indictment against him. The difference between that and NSA and whether it's 702 or 215 is everything gets swept up with no target, right? On the hope or the thought that maybe 2 years down the road we can connect the dots, right, by using it. So really that's the difference. I think it's a little too hypothetical for me in terms of that.
It's not for me. Just maybe because I was a law professor for a while. And, I like hypos. Think the D.C. sniper case. Right? So I lived in D.C. During that time frame, and we were all scared. I lived very close to that Home Depot in Falls Church. In fact, that's the one I used all the time when I was fixing up our house, and was there the night before that FBI lady or government employee lady was murdered by John Allen Muhammad and his cohort. And imagine, and I don't think it's hard to imagine, that the NSA, in that case and other unsolved criminal cases with no terrorism nexus, if directed, could run sophisticated algorithms, especially when there's more than one scene, to figure out who was were there calls made at or near the time of the shooting, here, on these particular dates, and narrow down a class of phone call numbers. I don't think that's too hard to imagine. But the call of your question is, should that be allowed? And I don't think it should. I mean, these are criminal cases. I'm sure that there are a lot of shenanigans of a sexual nature, of a extortion nature, of a corporate fraud nature, of all sorts of other natures that the NSA could disgorge and tell us about if that was their mandate. But their mandate is much narrower, and I can hear the chuckles by you when I use the word narrow in NSA, but it's narrower to investigations regarding terrorism.
Let me just say, so one other thing on that, just on this question of use and effectiveness, what's troubling as well is because the argument always is, well, it helps us, it keeps us safer, right? If we didn't do this, we would not be as safe as we are. And in fact, over the years, the government has said, we've foiled plots, right? We have foiled terrorist plots through the NSA program, through enhanced interrogation and so on. But when you start to peel back the record there, not so clear. The two most recent reports on NSA, both by the Privacy Board, and now, if you look at last week's New Yorker, a very interesting article about the metadata program. When pressed, the government has been able to come up with one case in which all this metadata for 10 years has helped them solve or be useful in a criminal case, and it wasn't the most significant terrorist case. It was a Somali national in Los Angeles who was arrested and finally convicted for the Material Assistance Act, sending money to a Somali terrorist group, several $1,000s. That's the only case in 10 years and billions of pieces of data in which the government claims that this program has actually been effective, the one case that they couldn't have done what they did without connecting the dots. Now, I don't expect the government to bat 1,000. I don't expect the government to bat 300. But when you look at those numbers and you compare them as well, when you start looking at the record at enhanced interrogation and torture, same argument was made. We need it. We're safer. We foiled plots. The Senate report destroys all that. In fact, it shows just the opposite. When the FBI did the interrogation and we had the right people doing the interrogation, we got good information. When we tortured people, we got bad information and we got no information.
Okay, let me switch.
And so there's always this temptation to say we need it to protect ourselves, but be careful before you accept that proposition.
Let me switch gears now to a more political question, less legal question. In his State of the Union address last month, the president said, quote, As Americans, we cherish our civil liberties, and we need to uphold that commitment if we want maximum cooperation from other countries and industry in our fight against terrorist networks. So while some have moved on from the debates over our surveillance programs, I have not. And he went on to say that his administration was going to issue a report about how to keep their promise to keep their country safe and strengthening privacy. Then, since then, the president has announced that that the country will stop surveilling foreign leaders' telephones and is beginning to announce some measures to strengthen privacy. Is there some irony in these announcements? Is the Obama administration responsible for a great expansion of the surveillance program? And are they doing the right thing to take these measures? Are they really going to take them, first of all? And if they are they doing the right thing to curtail the surveillance program? Charles?
It's, I'm sure, not going unnoticed to some of you that Angela Merkel is coming to Washington soon to visit with the president. And of course, when the disclosure came out that we were listening to her phone calls, I'm sure she was not very happy. But what we did announce is not
Probably not surprised.
I would think not. Newsflash, we spy on other countries, and they spy on us. They're spies in Philadelphia right now. And what we did announce is that we wouldn't tap the phones of certain key leaders in countries. Germany, Australia, Great Britain are very close friends. We didn't say everybody, nor should we. I think the political question, the answer to your political question is taken cumulatively, and this is why I framed my opening remarks this way. I don't think there is any doubt that this administration has expanded the use of federal power across the regulatory state, in trampling on religious liberties, on all the things we talked about this morning and in the afternoon debate, in a whole host of areas. And I think that whether it's true or not, bleeds over into our discussion about national security. Because I would say, and I would put to you, that when you have the top intelligence service in our country, arguably the DNI, having a website telling you everything they possibly can tell you about how they're transparent and reforming a very valuable 702 program and an arguably less valuable but important tool in 215, we've come a long way. But I think here's one thing and I'll say this to you very quickly. Here's one thing I always love about my liberal friends. We always agree violently that the federal government's gotten too big. We disagree about which parts of it,
Right.
but we always agree on that.
David, what do you think? Is the Obama administration responsible for an expansion of federal power with regard to surveillance? If so, is the administration right to suggest that it will cut back on that surveillance?
So quickly, because I think we should open it up. I don't know. I don't know, because a lot of it's still secret. There's a lot of stuff that goes on which we don't know. Obama has not been much different from Bush in many ways on some of these issues. He drew some markers, no more torture, and so on. But what is so I don't know enough. But what I do think is important is that we're having this debate. We would not have it if Snowden had not made that disclosure. Congress will have to decide about 215. Congress will have to decide about 702. The president will have to decide politically, where he's going to take a position between surveillance and privacy. We all can be part of that debate now. We never were part of it because we didn't know what was going on. And through history, I think the point here is when stuff is kept secret on the theory that if we disclose it, it's too risky for people to know, we normally find out it's not so risky. That the details of this program, not the calls that were made and not who said to what, but the fact that we're doing it as a democracy, if we don't have that information, I think that's very damaging. And I think the other illustration of that is the drone program, right? Which for years went on information. We had no idea what the metrics were, what the characteristics were of who we were targeting to kill, what probable cause meant, who was making that decision. And once there was a debate on that, and once we had to decide how to do that, the program became more limited. It became more targeted. There are fewer civilian casualties, and probably fewer strikes. So again, regardless of how you feel about the merits of those, and we'll probably disagree on that, it's hard to think that that debate wasn't worth it.
So just yes or no. Snowden a hero? Charles already said no. He's a traitor.
Certainly not a traitor. Hero, to me, I think he did the right thing, the same way the FBI burglars did as well.
Maybe we could open it up to the audience on that particular question. Snowden a hero? I'd love to hear a few responses on this, and then we'll take whatever questions you have. Anyone want to comment on that? Hero or a traitor?
You ready to jump in? Details of the H-bomb? No. On the other hand, Ellsberg, remember we had the same argument about Ellsberg? He's a traitor, right? He revealed all the lies we told about Vietnam. It's going to bring us down. He did the right thing.
Others on this topic, briefly? One or two other comments on Snowden? Okay, general questions. Yes.
Yeah, well, you'll make a good trial lawyer because that's a version of the "Have you stopped beating your wife yet?" type question. But I'll take it a different direction. There's some practical limitations to that, but I'll acknowledge at the very beginning that unless we hire people in the government who are completely untrustworthy and don't check them on the box, on the polygraph, and we don't follow up on them and we don't have good supervision, anything's possible. But insofar as the querying of the seed numbers at NSA, like I said, last year, 114 queries overall in the 215 program. You have less than 24 people who are authorized to make those queries. Those people are supervised. They have to get express written authorization from their bosses before making those queries, and there are a number of checks within the executive branch in the NSA itself and beyond when that information develops the data from the first and second hop. Remember, Obama trimmed it down from 3 hops down to 2 hops. A hop is I call Claire, Claire calls David, David calls somebody here. So that's the first hop, second hop, third hop. Now it's just 2 hops. So you're right in the sense that if we think the people there are evil and they're there to air our dirty laundry and are trampling on our rights, not much is going to be able to stop that. I don't believe that. I will say this, though. As a person who has a security clearance and had one of the highest ones you can have, and like any military officer, I mean, imagine if 50 military officers got together at Smokey Joe's here, all right, if that bar still exists, and they decided after 10 pitchers of beer that, everything we know, we're going to have a classified nature, we're just going to stick it on a thumb drive, and then we're going to run over to the Ecuadorian embassy overseas and give it to Julian Assange so he can put it out in the world to see. I mean, nothing's really stopping those officers from doing that, except their honor and their integrity and their oath. And most people in the federal government who have access to this information, all sorts of information, in the Commerce Department, in the Treasury Department, don't abuse their privilege. And so that's why folks like you who go to these conferences and then pass the bar and take an oath, live up to your oath, which you should do. And don't be a criminal like Snowden.
Yes. David, do you want to start with that?
It's a point I think we probably agree on, and there's always the risk to push the envelope, right? Korematsu, it turned out, not only was wrong, probably constitutionally without that, but now we know they gave false information to the Supreme Court about the depth of the threat or whether the
Does everybody know what the case
exists or not. So Korematsu is a Japanese exclusion case, and during World War II litigated when the 10,000 Japanese were put in camps in the United States. They challenged it. Supreme Court heard the case, said it was legitimate, in part literally because the Solicitor General misrepresented in its briefs knowingly the facts about what they knew about the threat that Japanese citizens would make. Now, we didn't know that for another 30 years. That was history later. A guy named Professor Irons wrote a very interesting book on that. And then ultimately the courts obviously, and everybody says we made a mistake regardless of that. And you always have that risk in all these situations, which is why even with the best of faith, right, we have a limited number of people who can access that data, right? The fact is the data is there, right? It's maybe destroyed after 5 years, but when you have so much of that there, there's always the risk of people doing the wrong thing with that, so you've got to be aware of that. And there's always this temptation when you can't defend what you're doing to try another course. So, just on this, it's not the same thing. It wasn't to the Supreme Court. President Bush in 2003 on Anti-Torture Day, International Anti-Torture Day, right, gave a speech. This is in the middle of a torture program in the United States, Abu Ghraib, Gitmo, secret prisons around the world, not only saying, don't we torture, but we lead by example. Those are the words he used. We lead by example. So my only caution is be careful what you accept from anybody, whether it's Obama, Bush, Roosevelt, Truman. There is in times of war and in times of terror, um, uh, forces that push people to do things that they really shouldn't do.
Did you want to comment on that, Charles?
In fact, I wholeheartedly agree with David on that. I don't have anything to add except one little factoid, and that is Abu Ghraib actually happened after that speech.
Other comments? Yes, sir.
I was chuckling during the election law panel because, number one, it's obviously nobody here grew up or voted in California because their ballot measures are, longer than a roll of Charmin. So, Pennsylvania, I mean, please give me a break. Be on a 3x5 card. But as a former resident of California, I was chuckling because, let me pivot off that because it's a little tangential. I would say that just because somebody does something illegal which causes a discussion doesn't mean that you can't be against the illegal thing and for the discussion. So I remember very vividly, I was stationed overseas in Europe during the Balkan War, a hardship post in London, and the OJ verdict came down. And I remember the next day, the biggest tabloid in London said, "What a farce." And I remember having this debate with several of my shipmates and Marine buddies, and their opinion about the verdict broke down clearly on racial lines. It was very clear. 10 years later, when polled, that divide has changed. But one aspect of that was, if he did it, was it justified? I don't think anyone can justify murder. But you had people saying, not really coming out saying that, but that was sort of behind their comments. I think what he did, to my point to this gentleman, was a violation of his written rules and non-disclosure agreement that he signed as a part of his employment. That all officers, whether you're a contractor or actually in the military, are required to uphold. And we cannot have an army of people who have access to all sorts of sensitive data disclosing that. If we're as concerned about the human condition as your question seems to surmise, and it applies to government employees, wouldn't that apply to everybody? Why aren't we concerned about Facebook employees using our information, or people at the phone companies using our information?
Charles, let me ask you a question. If Snowden really believed that there was an illegal practice going on, what should he have done?
Well, take Tom Tam, for example. Okay, Tom Tam worked at the NSA. He and I used to be prosecutors together in Maryland before he joined the NSA. He was one of the 8 leakers prosecuted by the Obama administration. And Tom did not use the quitam procedures, the procedures within the department, to raise concerns about the constitutionality or illegality, setting aside the constitutional issue of the programs. And so I think, given the procedures that are available, that he had available to him, he could have done that. But I don't think that Snowden, first of all, he's not a legal scholar. He just didn't think the government should be doing this. He had a principle gut instinct that this was wrong and the American people should know about it. I mean, when I've heard him at various conferences. He appears by video. And I think that's generally his, I'm not channeling my inner Edward Snowden, trust me, but that's generally what he's saying.
Okay, more questions. So we can go till 3:30, right? 4:30, excuse me. So a couple more, yes.
100% yes. We did a panel event at Heritage on that. I hosted the panel. You can watch it on heritage.org. Let me tell you why this happens. It's a cultural thing within the executive branch. You have a computer. You usually have two screens. You have a NIPPER, not an unclassified computer, and you have a classified computer. And the default for most emails is the classified. I mean, it literally is that simple. The computer folks set up your computers. When you're a policymaker, you don't come in and decide, you don't worry about defaults. You just do what you're supposed to do. And we're just creating reams and reams and reams of documents that are titled classified when, in fact, we're hurting ourselves in the process by doing that.
David, your remarks about transparency suggest that you would agree. How far would you push back the classification practices?
It's not big. I think it happens, right? And we overclassify, and every profession does that. Lawyers claim everything is attorney-client, right? I mean, everybody, you kind of protect your turf and so on. So I understand the bureaucracy doing that. And it's inevitable that's going to be the default position. If there's a question, protect yourself, classify, right? Because if one thing gets out, then you're really on the hook. I think the answer to that is not so much, which that document or that, but when we talk about programs, I mean, it's one thing that this document or that document and how much you can have a good faith debate about whether that ought to be done. But when we talk about these kinds of programs, the fact of them, not the details, is the kind of thing that I'm concerned with, that the secrecy that we build in, and it always happens, right? We keep this stuff secret, and not an H-bomb, not how we build the bomb, but whether we should engage in this kind of surveillance, that's what ought to be open to public debate.
Last one? Last question. Keep it brief.
Yeah, it's a great question, and of course my answer is standing between you and the bar, so I'll be brief. There's a factual insufficiency to the premise of your question, and that is, I would say, that yes, your phone records, more likely than not, are within the metadata program. They've never been queried. And more likely than not, none of your data is in the 702 program because you aren't communicating with folks overseas who are known terrorists. And if you are, it hasn't been queried, probably past one initial look without looking at the content. But I agree with your general premise.
Thank you very much. It's been a great discussion.